Local economy solutions are what my show is all about. This is David Tulis, and we're trying to find ways that we can avoid the problem of giantism. Giantism is when you look at a situation with the local evidences of it, and you think the only way we can fix this is to encourage Chuck Fleischman, our federal representative, to write a bill and pass a bill that would change something, some tinkering in a sequence of words in the federal code 1,000 miles away, and that somehow, if those words are adjusted with the consent, of course, of the rest of the House and the Senate and the signature of President Trump, that evil thing about which we were complaining will cease. It will just go away. There won't be further ado. Well, to think that you can change things politically like that is simply ludicrous. It's ludicrous because it simply doesn't happen. There's not a constituency. There's not a lobby for the easing of the evil about which you are concerned. That evil is there, and there's no constituency to change that. So you can write a letter complaining about something, but that's just one of 1,000 pieces of correspondence every month that Chuck Fleischman gets complaining about something and urging that something be done. I mean, so he's not going to do anything about it. Okay, even if you showed up with 10 members of the Chamber of Commerce and said we're concerned about this law, well, you might get 20 minutes of his time, and he'll very seriously, with his hand on his chin, look at you across the desk and say, well, I really appreciate your filling me in on this. I was not aware of this problem. And you're right, it's a grave concern, and I think it's really unjust that these kinds of things are happening. And let me consider what you have to say and see if I can maybe rustle up some support. Well, those are all very earnestly meant. Okay, they're intended at the moment that they're uttered to be genuine, but in the end, he meets people like that 4 or 5 times a day, wanting something done and so on. So these are the thinking, the giantist thinking about which I'm complaining, holds that that's effective, holds that that's a good use of your time, your money, your travel expenses, your lobbying budget, and so on. But these are amiss because the problem won't be solved. The injustice will not be remedied. That the services law, that the federal services law that had people being convicted of crimes for business practices, it was overturned finally by the high court, is overturned by the high court, right? That's how you undo it, is you do it in court. Court is how the left, the humanists, the queer lobby got all of its great successes, is by litigation and having people lay themselves down as defendants, right? There are people who are convicted of a crime, and they become the cause célèbre, the celebrated cause, the reason for reform, led legislatively, often by court rulings. And that we've had that now for 50 years, and that has brought about the idea of the activist judiciary. Well, again, these are high and mighty topics, but we're here in Chattanooga, right? We're here in Hamilton County, and you, my listener, the man traveling through on the highway. And I do watch the road and mind your commercial postings there. You're from another place, and everything I say can be applied at your hometown as well. Nothing that I say is trademarked, and the ideas are not copyrighted. And so you're free to cut and paste as you wish. Love your neighbor, buy local. That should be on every locally owned store as a banner over the aisles, right? Love your neighbor and buy local, and use cash. That's one of our arguments, is use cash because cash is personal, cash is immediate. Though legally it is sclerotic. Cash, Federal Reserve note cash, still though represents a bit of freedom and a bit of self-liberation from the tapeworm economy that we by which we are surrounded. Now, the question about bad laws and evil laws, I think, is important because you can queer the best outworkings of judicial study in a prosecutor's office by simply saying no as the juror. And I think we need to consider how that works and what your privileges are, what your rights are, and more importantly than those are your power. Right? You have a power. As I was thinking just this morning, you have 3 boxes to protect your assets, and that would be not your personal assets, not your checkbook and your gold watch and your little cache of firearms. Those are personal assets. But to protect your assets, in the larger sense, in the sense of you're being a civic person, right? A person in the city or a person in the county. They are the ballot box, the bullet box, and no, I'm sorry, the ballot box, the jury box. Forgot that one. And the bullet box. Jury power is gaining a great deal of strength. There are some very evil things happening against jury power activists. There was a man convicted and sentenced, a minister of the gospel with 6 or 7 children, was protesting the abusive prosecution of the Amish farmer with his balms and salves, and he was giving passing out fully informed jury association leaflets outside the court, and he was maliciously prosecuted and found guilty of jury tampering. Now, jury tampering is something that routinely happens not by outside activists with fully informed jury association flyers in their jacket pockets. These are done. This process is done by judges and by attorneys who keep their mouths shut because they know what is good for their standing among fellow guild members. And that is that you, the juror, do not judge the law. You judge only the fact. You're a finder of fact. And that is, of course, the main reason why there's a trial. If issues in a dispute are purely legal, there's no need to have a jury trial. You simply stipulate the facts, and that's done in negotiations. Each side stipulates facts that don't have to be thus argued. Right? If you can come up with stipulations and agree on all the facts, then the question simply is a matter of law. What is the law as seen? Is it correctly as seen by the prosecutor or your side? Right? You're the defendant. And so some cases turn simply on what the law means, and the judge then is given the task of determining the law on the facts. But often facts are at issue, and so juries are impaneled to find those facts. That's what a jury trial is about, finding a fact. But it's really better than that. And the obligation that you have as a the obligation you have as a juror is to rule on the law. You rule on the law and the facts, and that is in the Tennessee Constitution. I'm just the reason I was stopping talking there for a second was that I was looking in the Bill of Rights, and here it is. Well, I'm looking at facts in the okay, ex post facto. Okay, here it is. It's section 19. It's kind of a long passage. It's about the printing press shall be free. And should I read that to you? Let me just move on here where it says the free communication of thoughts. It's at the very last bit of this. There's about a couple sentences. The free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. Now, we're entering into the realm of libel. Okay, here we have a free press, right? The press is free. It's a constitutional right to be in the press, and you're free. Okay. However, now this is the part where the idea of jury nullification is in the Constitution of our state. Okay, this is section 19 in the Bill of Rights. He goes on to say, but in prosecutions for the publication of papers investigating the official conduct of officers or men in public capacity, the truth thereof may be given in evidence. So if you're accusing as a writer or a journalist, a public official of malfeasance or misfeasance or a crime, the facts are your defense. You just simply have to turn the trial about the public official. The trial becomes not in a prosecution of you as subject to a libel claim. It becomes a trial of the public official because the facts about him, right, the things you were saying were facts, and whether they were or not, that's the issue, and that is your defense. So your defense is the facts. Now it goes on to say, and in all indictments for libel, the jury shall have a right to determine the law and the facts under the direction of the court, as in other criminal cases. So that is the key language. The jury shall have the right to determine the law and the facts, and there's a proviso here, under the direction of the court, as in other criminal cases. But since we're talking here about the Bill of Rights, that phrase, under the direction of the court, should not be construed as in any way lessening that authority. Your authority is plenary. In other words, it's full. You, the jury member, You, my listener, here at Nooga Radio, AM 1240, FM 92.7. You, the listener, at 95.3 HD4. On YouTube and on Facebook, you have a plenary, which means full, a full and complete right to judge the law, as it says here in the Constitution, to determine, you got that? That's the verb, the law and the facts. So you determine what the law is. If it's a bad law, like this resisting arrest statute in Title 39 of the code, or wait, is it, yeah, Title 39, that you determine that law. In other words, you rule on that law. You overturn the law in that case by ignoring it. And you can do that by your conscience. Your conscience, which is informed by your life, which is informed by your soul, which is brought into his presence by your life experiences, your wisdom, your bad experiences, your good experiences, your commitments, right? Your love and faith commitments, your worship of God. These all are part of your soul, right? You're made in God's image, and so you will tend to reflect, even though you're a sinner, right? Like I am, you will tend to reflect a good human perspective. And so some things we'll get wrong as juries. But I think on the whole, I would much rather trust my fate as an accused to you and people like you, common ordinary people, right, than to a lawyer or a judge. And I'm glad that the jury system is something that needs to be strengthened, and the process is being strengthened already. There are some good books. I have at Nooganomics.com today. If you're facing jury duty, make sure you go to Nooganomics.com today, because there is a post by Joel McDermott of American Vision, and he has a couple of resources. One, what you call secular, and that's Find a Fully Informed Jury Association, and then there's a book, and I've just today came across a very fine writer I hope to track down and introduce you to about this question. But again, the Tennessee Constitution says the jury shall have the right to determine the law. Determine, okay, that's the active verb, determine, which is to say to frame and nail down, to fix, right, to find, understand, and fix the role of, the scope of, the venue of. That is what determine means, okay? You determine the law and the facts under the direction of the court, as in other criminal cases. So it's not just in libel that this power exists. Now, I'm not sure about criminal libel trials. I've not really heard of that. So I'm not sure what the founders, the revisers of this Constitution meant by that. But because libel largely is a civil matter, unless, of course, perhaps a judge claims to be libeled by, or a state representative libeled. But it's hard to really make that a criminal matter, because if you're a public figure, you really cannot be libeled. You can't libel me, David Tulis, because I'm a public figure. Even though I'm a very retiring person, very shy. Actually, I'm a very shy person. I cannot be libeled. You can certainly say what you want about me. And I think a few people actually say mean things about me. There are a few. I do believe I've seen some comments. Now, again, just that last phrase, as in other criminal cases. So in every case, whether it's a murder trial, a trial for drugs, a trial for violating a paper law, these are ones that you should understand are to be overturned. You overturn the law, or you overturn the use of a good law in a particular case. Now, there are the crimes I'm thinking about are commercial crimes, and often they deal with cars. It's amazing how few cases go to trial that are about the abuse of the commercial transportation statute upon the poor traveling public. We mentioned yesterday. And I plan to write an article catching my Nooganomics.com readers up on a case in Nashville, filed in January, about this abuse of the driver's license statute. Driver's licenses are a right, effectively. They're a privilege, but what has happened is if you don't pay your fines and fees, you can be given a civil death sentence by the refusal to be given a driver's license or the revocation of it. And that makes them criminals if they use cars, right? They become criminals to use cars if that system indeed applies to them, which I say it doesn't, but most people think that it does. So let's grant that to them for now and say that the driver's license system is a death penalty. It is a civil death penalty on thousands and thousands and thousands of Tennesseans. Hundreds in Chattanooga. Hundreds are under a civil death sentence. I know one or two of these people personally. They are under a civil death sentence, and if they're caught in their cars traveling, the accusation will be that they're operating motor vehicles as drivers and they don't have their papers in order. They will face another criminal charge. They will face arrest, citation to Sessions Court. That's what happens, and that it's an abusive system. So very few cases like that get to trial. But now, if one does, I'm counting on you, my listener, to be the man to overturn a wicked prosecution, because that's all it is. It may look like the state has it all sewn up in that case, but it's wicked, it's evil, it's oppression. It's simply oppression. Most people who are caught up in the jail industrial system are poor. They're poor people. They don't keep track of dates. They have no means. They can't buy licenses. Licensing regimes are inherently discriminatory. Have you ever thought about that? They are discriminatory of whom? Well, people who don't have money. And you can say, well, that's just the way it is. You have to have money to do things. I hear flip comments like that even at home. More conventional thinking, it does happen sometimes at my house. People, if they can't have a license, they shouldn't be on the road. I mean, people if they're not safe, they shouldn't be there. Well, what about if you're 40 years old and you've been driving all your life and your license is revoked? Who's to say you're not a safe driver? How does that mean you're not safe? It doesn't mean that at all. Having a revoked or suspended or expired license doesn't mean anything about your quality of the safe use of a car or truck. And in fact, in the Hicks decision, the one that deals with roadblocks, the high court is waiting for a case that raises that question. It is waiting for that case to show that licensing has nothing to do with public safety at all. Nothing. It does not increase public safety. It does not increase public welfare. It does not enhance the health of the people of Tennessee. The high court is open in the Hicks decision, which, by the way, was a Suck Creek Road roadblock decision following the Downey case that laid some groundworks on the use of roadblocks. Roadblocks are unconstitutional, but the Tennessee High Court allows them. They're unconstitutional, but the High Court allows them. We don't have law in our state much anymore, and I'm sad to say that. And so that's why the idea of the jury nullifying a prosecution is important. And it is, think about this, it's local economy. We don't have to change laws in Nashville. We don't have to send delegations up to Washington to change laws. We can just say, well, all right, just let the prosecution come. And when it comes down here, when it abuses one of our residents, we'll put our heel on it. We'll squash that prosecution like a bug on the cusp of our doorway. Like this morning when I was coming back from my mother's house after breakfast, there was a beetle that had just climbed up the concrete step there as I walked into my garage. And I thought, wow, what a big fat beetle. And I put my foot on it, just tapped it. I didn't want to mess up my shoe. I just tapped it and it crushed it right there. You can do the same thing with a prosecution. A little crunching sound, right? A little crunching sound, little legs squirming to the side, fluttering a bit as you pass over it and go inside and get your briefcase together and your billfold, and you put your keys in your pocket and head on out to the office. And I'm really glad that you did that today and that you've got me here just for a minute. That's all I need from you, my listener. Just a couple minutes, just a couple of minutes of your time. And now, but the question, how is it that we can queer a prosecution? How is it that if there's a prosecution that you can queer it, you can mishear it, right? And I have a funny example of how this would work. And just pretend for a second that Target wants to build a new store in Chattanooga. Of course, we're hugely overbuilt on retail. We're at the top of a retail bubble right now. And we're going to have a lot of empty shelves in the next few years after the collapse. But let's just say that Target wants to build another store in which to herald gay rights, right? Herald the Noah's rainbow color with its altered meaning, of course, over a case of school supplies and little bags and treats and things, okay? And to get that store built, there's a last holdout in the development area. That's a widow. Target needs to have that widow out of the way. And so And so it is going to petition for a condemnation proceeding. It is in the public interest, after all, to have more retail. Right? We have to increase our tax base here in Helena County. What does the juror who's got some hearing problems do? Well, this is David Tulis. I've got thinking problems. I am the slow man of Chattanooga. That's why you count on me with my bow ties to shine a light on things. I ask the slow man questions. David Tulis, the slow man of Chattanooga. There are just so many things I just don't get. And so, on your behalf, I ask the right questions. Lord willing. David Tulis.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.